Thank you very much. Good afternoon, everyone, and thank you for joining us. My name is Brittany Forrester, and as you see on the screen here, it's a little bit of a biography about myself. I've been practicing in this area since around 2020, prior to COVID. I've worked with just about every agency there is that hold a security clearance, whether it be the Department of Defense, Department of Energy, the FBI, and several of the other three-letter agencies you see there. So dealt with several of the issues that we're going to talk through today, both with military service members security clearances, federal employment security clearances, and also contractor security clearances. This is a disclaimer. If you could read that just briefly, this information is for educational purposes and cannot be construed as providing legal advice. Pretty straightforward. All right, so today we're going to be talking through the adjudication process for Department of Defense contractors, military members, federal employees, primarily the Department of Defense, the regulations which govern each, and the two different processes under each of the executive orders listed there. I'm going to take you through the application process, the appeal process, and then the reapplication process if you were to be denied or you hold a clearance and have had that clearance revoked. So first we're going to talk about the adjudication process from start to finish with DOD contractors. First, you would obtain a sponsor in a position that requires a certain level of clearance, whether that be a public trust requiring the SF-85P form, which is a lightened version of the SF-86, whether it be a secret clearance or a top secret and potentially needing additional access to secret compartmented information, which is SCI. After you've obtained your sponsor, you would go through their normal application process, and part of that process is they're going to submit a request for you to have a security clearance application, which is the SF-86. That is now sent to you typically through the e-app system and completed on the computer. Once you've completed the SF-86, you will then be contacted by an investigator with the Defense Counterintelligence and Security Agency, also known as DCSA. They will reach out to not only you to conduct an interview for your personal subject interview, but they typically will reach out to the individuals listed within the past employment section, the people that have known you for a number of years section, and really any other contact information they may find throughout their investigation. They may conduct interviews of those individuals as well. So it's important to prepare for that and to cooperate and provide the additional information in that interview that they're requesting. If not, that takes us to number 5. That can be a potential reason for you to receive additional documentation after you've submitted the SF-86. So there is a document they could submit to you called a request for interrogatory or letter of interrogatory. It's alternatively known as a supplemental information request. And they would either submit that because maybe they find something in the investigative process that you failed to report or mistakenly overlooked on your form and didn't complete the form entirely. It may be something that could be potentially derogatory and disqualifying that you were open and honest about, but they have additional questions and would like additional documentation. Now, this step is not the first step in the process of attempting to deny or revoke a clearance. It's simply part of the investigation process that requests additional information, which is determinative of the decision of whether to issue a statement of reasons. And that takes us to number 6. The issuance of a statement of reasons typically comes alongside a notice of intent to deny or notice of intent to revoke. And then the statement of reasons is the listed reasons of one or more of the 13 guidelines, and we'll talk about where those guidelines come from here shortly, as to why they have an intent to either revoke or deny the clearance. And then not only do they provide you the guideline, but they also give you a specific detailed explanation of why it could be a concern under that particular guideline. Now, with the statement of reasons being issued, you have the opportunity to provide a written response. That written response goes back to DCSA for an adjudicator to review the entire file and ultimately determine whether or not the clearance is granted at that part or whether it would move on to an administrative hearing before an administrative judge with the Defense Office of Hearings and Appeals, DOHA. If it moves on to a hearing, you have the opportunity to be represented by counsel. The government typically will have an attorney present as their representative, and the administrative judge would ultimately issue a decision on whether or not it is clearly consistent with national interest for someone to have or continue to have their security clearance. Now, the timeline for that is the most difficult question I get asked during almost every conversation on the security clearance process. It's very difficult to determine exact timelines because none of the executive orders or directives really provide guidance and restrictive deadlines on the investigation process or the adjudicative process. So it can be a challenge to determine approximately, how long from start to finish a clearance investigation could take. Now, it's commonly known top secret can take, I've had them take up to 12 months, sometimes over a year, just depending. Secret and public trust are typically adjudicated a bit quicker than that. As I mentioned, we go over the executive orders, and of course, the lengthy paragraph there, I'm not going to read it out to you, but this executive order 10865 designates the process and the procedural due process that one's owed when they are in the process of having their clearance adjudicated or potentially revoked if they have a clearance. It states that you're required to get a written statement of the reasons why the access is either being denied or revoked. You have the opportunity to provide a written reply and additional supporting documentations, and you have the opportunity to present before an administrative judge should that written response not be sufficient. Now, earlier I mentioned the statement of reasons would present certain guidelines as to why you were either being considered for denial or revocation, and those are found under Department of Defense Directive 5220.6 and incorporated through the SEAD 4, which is the Security Executive Agent Directive SEAD 4. In that, there's 13 guidelines, and they range from anything from allegiance to the United States, foreign preference, foreign influence, sexual behavior, financial considerations, personal conduct, criminal conduct, alcohol consumption, illegal drug use, psychological conditions, handling protected information, outside activities, and use of information technology. And I think I covered them all there, maybe a bit out of order, but there are several reasons, as you can see, as to one might have concerns for the government to review when they're applying for security clearance. One of the most common that comes up is Guideline E, and why we've done several webinars on completing the SF-86 accurately and honestly and participating in that interview to the best of your ability, because lack of candor is one of the most common and most difficult guidelines to overcome when you are working with a statement of reasons and an appeal in general. As something that could be as seemingly minor as a financial account that maybe came from a past medical bill that you forgot about or didn't know about could pose a concern for the government should they locate it and it's not being paid or worked towards to be paid off. That could be another concern for the government. And then you get much more egregious things like mishandling of classified material for those that already have a clearance and are in the process of potentially having it revoked. You've got individuals that have allegations that they've misused government technology, government computers, government vehicles. You have certain allegations that could be presented if you have outside employment that's not allowed with your current federal employment or contracting employment. You have several circumstances under those 13 guidelines that can pose an issue in either obtaining or maintaining a security clearance. All right, so the DOD contractor appeal process, which I've touched on a bit, once it gets to the administrative judge and the administrative judge issues a decision, should that decision be unfavorable, and now let me backtrack a little. When you get that decision, let's say you had a statement of reasons that was alleging 3 different guidelines, Guideline E, Guideline F, Guideline G, just for example. You can have a hearing decision after you've gone to the hearing where you're successful on some of the allegations, some of the guidelines in full, and all of them or none of them. So for example, if you have a Guideline E, F, and G, you could have been successful fully on Guideline E, and now that's no longer a concern for the government. You could have a concern under Guideline E and F and still have to fight Guideline G to obtain your clearance. So with that being said, you have an appeal process, and both the department counsel and the applicant can appeal a decision. So if you're favorable, it is possible that a department counsel could come back and file an appeal if they chose to do so. And how that works is you'll receive a decision from the administrative judge. Once you receive that decision, you have 15 days from the day that it's dated. And that's very important because they mail these decisions typically. So you have a quick turnaround time from the time you actually receive it and the time that you have to file that appeal, because again, it's 15 days from the day that the decision is dated. So just make sure you note that. And then typically the appeal board will send a notice that they acknowledge your notice of appeal, and they will provide their own deadline for you to respond to the appeal with a brief in support of the appeal itself, and for you to be able to provide any additional supporting argument and testimony in that appeal. Now, it goes to look at everything that's within the file that occurred at the hearing. So you wouldn't be able to submit new evidence at this time. Now, if that appeal is unsuccessful, the reapplication would occur 1 year from the administrative judge's decision. So it's not the appeal decision, it goes from the administrative judge. You would have to obtain a new sponsor. It could be the same company. Maybe they maintained you in a non-classified position. They could resubmit you for security clearance after that 1 year period, and you would complete a new SF-86. After you complete that SF-86, it goes up to the Defense Office of Hearings and Appeals, and they will send you a letter and allow you, I think it's a 60-day period for you to provide additional documents and mitigation and support to mitigate the previous concerns that were still left at issue when your clearance was ultimately revoked. Once they've reviewed your documents and additional mitigation, if they approve it to go through for reapplication, it goes back to the DCSA VROC, the Vetting Operations Center, and they conduct a new investigation. If there's no new derogatory information that's found during that investigation, it's typically a successful clearance reapplication. All right, so this is the regulations for our federal employees and our military members. You see it's listed there. It's guided by Executive Order 12968 and DOD Manual 5200-02M. While the process is similar, it has some distinct differences. However, it still incorporates the SEAD 4. So those 13 guidelines that I discussed earlier are still incorporated. We're going to go through the DOD military employees and military member appeal process, and then I'll describe the distinct differences between both and point those out. First of all, you receive a written decision from DCSA, and then you have the opportunity, and let me go back just a bit. So once you've completed that same investigative step, that the interview, the SF-86, you receive that statement of reasons, you would receive a letter from DCSA. If they're going to deny or revoke, it's actually a letter stating that we've made a determination to either deny or revoke your clearance, and we refer to it as a letter of revocation or letter of denial for the reasons. Now, similar to being able to mitigate some of those concerns at the hearing, you can actually mitigate some of those concerns in your written response to the statement of reasons. So let's say you have, again, guideline E, F, and G. When you get the letter of denial or letter of revocation from DCSA, you could have potentially mitigated one or all of those at that time frame. If not, the appeal process is where things become a bit different. Once you get that written decision from DCSA, you have the opportunity to provide a sole written appeal where there's no hearing, no personal appearance. It's just simply asking them to consider the clearance decision again based on all the information you provide on appeal in a written fashion. Now, in lieu of that, you have the opportunity for a personal appearance or a hearing before an administrative judge. The hearing itself is very similar from the DOD contractor hearings to the hearings for federal employees and military members, where you have the opportunity to be represented by counsel. It's an administrative judge that is conducting the hearing. You have the opportunity to present witnesses in both of them. The difference is that the administrative judge issues a recommendation. So they submit whether or not, based on the evidence you've presented and the testimony you've shared, they recommend that you should obtain or maintain a security clearance, and they present that opinion to the Personnel Security Appeal Board, PSAB. PSAB reviews the entire file, and mind you, you will not get a copy of the administrative judge's opinion. So you don't know at the end of your hearing whether or not the judge has recommended or advised the PSAB not to clear your clearance. They have the ultimate say. They conduct a brand new review looking at all of the case facts, all of the documents you presented from a very fresh new standpoint, and you are allowed new evidence on appeal. Now, this reapplication process is similar for military and federal employees. If you are ultimately denied, it goes 1 year from the date of the PSAB Appeal Board decision. They're the final say in this realm. So 1 year after that, there is no actual process as I described before. You're not going to get the letter from Doha and the opportunity to present the additional information within 60 days. Instead, it goes under normal investigation and the adjudicative process. And of course, you in your SF-86 do have to report that you've had previous suspensions or denials, and that would be taken into consideration. But ultimately, the process is similar. All right, so the major differences, as we've talked through at length, for contractors, you have the opportunity to appear personally before they issue the denial or revocation. So the difference in that is, as military members and federal employees, getting that letter of denial or letter of revocation prior to their appeal is part of their appeal. So that's your main difference, is that when you're a contractor and you get the statement of reasons, that's not the decision yet. When you get that determining letter from DCSA as a military member or federal employee, it is a decision until you appeal successfully with PSAB. So I know we're a little early. I'll touch base on a few things that weren't in my slides. So I know we were going to primarily cover Department of Defense federal employees, but I want to touch briefly on a few of the other agencies. For example, the Department of Energy, Department of Homeland Security, some of your other intelligence agencies have a very similar process where you apply for the clearance, you complete the SF-86, you undergo an interview. You may have to undergo a polygraph as well, depending on the level of clearance and the access that's needed for it. But when there is a denial or a revocation with those agencies as well, DOE is a little bit different, so we'll set them aside for just a moment. But several of your other intelligence agencies, such as the NRO, NGA, and a few of the other three-letter agencies, they will similarly provide you the statement of reasons as to why you would be denied or have your clearance revoked, and you would have an opportunity to respond in writing. Typically, they will also allow a personal appearance, but instead of it being before an administrative judge, it's typically before a security appeals board, which is a group of individuals that review the entire case file and ultimately issue a determination. And most of the agencies have a second level review to that as well. Now, I skipped over Department of Energy because it is a little bit different. What they issue out is called a summary of security concerns. It's very similar to the statement of reasons. They utilize the SEAD 4 guidelines, and you have the opportunity to appeal by either a written response or a personal appearance before a Department of Energy judge, and you don't have the opportunity to do both. Now, at that hearing, you can present additional testimony and evidence and witnesses, and then there is an appeal process. If the judge issuing the decision for Department of Energy finds it unfavorable, there is an appeal process through the Department of Energy as well, and a reapplication process after a year, just as with the Department of Defense. I think we've got about 10 minutes left for some questions, and I had a few that were shared with me, so let me see if I can go through some of those first. Okay, so one of them, this is kind of specific, but I can touch on it with some other examples. For example, one of the guidelines I mentioned was Guideline I, and an individual has a question as to whether a clearance can be denied or revoked due to high-functioning autism. And it's a very interesting question because when you look at the Guideline I, it is whether or not there's a condition that could impair your judgment, your trustworthiness, and your reliability. So while any condition that may be seen or advised to impair judgment, reliability, or trustworthiness, whether it be a borderline personality disorder, there's several that are listed within the SF-86 that fall into that potential category, but it's not ultimately disqualifying. The agencies look at it on a case-by-case basis to determine whether or not the condition is under control, whether it presents any potential harm for you to be trustworthy, reliable, or exercise good judgment. So to answer that question, ultimately, it would not be fully disqualifying if you have a psychological condition such as high-functioning autism to be able to obtain a clearance. And I see a couple coming in through the chat. Give me just one moment. So this is a really good one. Is failing a polygraph a reason to lose your clearance altogether? So that's a great question because a lot of individuals have a clearance through Department of Defense, and then they have a higher level clearance requiring a polygraph through one of your higher level intelligence agencies. And yes, if they uncover information through the polygraph, whether it's a failed polygraph or you report derogatory information, that more likely than not could get reported back to your Department of Defense clearance and could definitely pose an impact on both clearance approvals and maintenance altogether. So yes, someone else in the comments asked if I've ever heard of a security suspension for a misdemeanor DUI charge, but not a conviction. So with criminal conduct and the answers on the SF-86, the SF-86 asks whether or not you've ever been charged, arrested, or convicted of a crime. And it asks additional questions on criminal conduct related to alcohol and or drug use and firearms. So even if someone has been arrested or even cited to the point where they have to appear in court summoned, then you do have to report that, and that could be disqualifying. There's absolutely things that you can do to mitigate criminal conduct, including DUI, but it's definitely a process of reaching out and speaking to someone with experience in the mitigating conditions and how those apply in a situation where there's even a DUI arrest. So let's talk about have you ever questions. I think those get overlooked quite a bit on the SF-86 because it can be confusing. It goes from in the last 7 years, has this occurred? And then it goes into several questions that are have you evers. And so a lot of times this comes up with criminal conduct, I think, quite a bit because there will be a charge or a conviction that's been expunged and sealed. And even though it's a charge that's been expunged and sealed, it's still a charge that occurred at one time and needs to be disclosed to the government in your security clearance application. And then, of course, in the explanation section, you can get into how the charge was resolved and now it's expunged and sealed. But it's really important that things like that are disclosed, because going back to my discussion briefly on Guideline E, a lack of candor is a more strict and harder guideline to overcome to show down the road at a hearing that you will exercise candor in the future if you failed to report certain things, either because you think you're not going to get approved or maybe even you forgot about it. But it's really good to do your due diligence and search through all of your records, your backgrounds, and make sure that everything is included, regardless if it's in the last 7 years section or in the have you ever section questions. Okay, so this is another question. An individual that is a contractor asking if it's common for individuals to be put on a leave of absence while the clearance is in the adjudication process. And in general terms, yes, that is very common. So typically, regardless if you are less so as a contractor, I've seen the clearances be flagged, but definitely federal employees, it's very common that if there's an issue with either obtaining or maintaining the security clearance, they will quote unquote flag the clearance in the DIS system, which is the Defense Information for Security System. It's where basically it houses who your sponsor is, what level clearance you have, when it was adjudicated, and when it's set to be re-adjudicated based on whether it's a 10-year or 5-year reinvestigation period. With that being said, they typically will flag the clearance. And so when that clearance is flagged and it's under investigation, you're not able to use the clearance. So with that, they will put you on administrative leave, or I've seen them do an indefinite suspension until DCSA or the agency in question has fully adjudicated the clearance. Now, upon a favorable adjudication, that indefinite suspension would inevitably go away and you would be brought back into your position. But there's no defined time as to how long that investigation could take and how long that indefinite suspension could last. This is a pretty specific question, but I'll see if I can answer it to my best of my ability here. Can the agency suspend you and remove your access if there is no documentation from DCSA, like an SOR, related to the potential concern after 2 months of being informed of the issue and an incident report was made? So that's a challenging question because once an incident is reported into the DIS system and sent to DCSA, there's not a defined time frame for them to either review the file and issue a letter of interrogatory requesting more information or issue a statement of reasons. So I've seen several times where an incident was seemingly reported maybe 5 or 6 months prior, and then they're issued a statement of reasons or a letter of interrogatory asking more questions about it at a later time because they're not held to a particular time frame from the time that they receive derogatory information till they complete their investigation and ask you to provide your response and more information on it. I think I got to one. I got to all the ones in the chat, but something I've seen, quite a bit is going back to how can one investigation impact another investigation. So with military members, I've had military members where they are also reserve and they are also a civilian employee. And even if they're not in reserve and civilian, they could be a military reserve and an intelligence employee with the federal government, with one of the higher level security intelligence agencies. It's very important to remember that derogatory information can definitely impact one clearance from another if information's later uncovered. So how this comes up a lot is you have individuals that were very young that applied, they misrepresented information on the SF-86, and then 5 or 6 years later, they're coming back to get an upgraded top secret clearance and possibly undergoing a polygraph and other investigative interviews, and some derogatory information ends up coming out that can really impact the new clearance being approved and the current clearance that they have. So it's very important, and I really reiterate this in every webinar that I do. The accurate reporting from the very beginning on the SF-86 is the best thing that you can do in any circumstance, regardless of what is in your background. It's always better to tell them about it up front, be honest, be forthcoming, and then provide the mitigation that supports why you're responsible and trustworthy and eligible to hold a clearance. But that's all I have for today. I appreciate everyone joining in and participating, and I hope you learned a lot from this webinar. Thank you.